virtually and thank everyone for attending this very important event. Firstly, I want to inform you all that the Lifestyles Media Department will be recording this event, and we're doing that so those families that were not able to make it are able to access our website and go on and view what is being said here today. So again, my name is Rita Beretti. I have a 39-year-old daughter that has intellectual and developmental disabilities. I am the director of a supplemental youth day half program, after-school program. The program serves individuals of ages 14 to 21. This program is a unique program that gives participants the opportunity to socialize, learn daily living, safety skills, and so many more. It is a without walls program, which means they're out in the community. If you have any questions about this and you want to talk to me about this program, please speak to me after this session, and I can give you information about the program. Now, Lifestyles offers many other great programs like respite, employment services, rehabilitation, among many other programs. So today, we gave you all a bag that includes our brochure, QR codes that will help you connect to Lifestyles. This way you can see all the wonderful things that we do here. We supply you with a booklet and a pen so that you can write down any notes. We also gave you a form that you can complete with questions for the surrogate team so they can help you. We will collect them and give them to them at the end of the session. We will do our very best to get your questions answered. We do have people in the audience as well as virtually. And Annette, thank you. Annette Rhea, thank you so much. She's going to be answering the questions virtually. I will ask you all to please limit your questions and to ask general questions. If you have any personal questions, please reach out to the surrogate court. I would like to introduce Janine Busto. She is our Deputy Executive Director of Lifestyles. Oh, I need to. Sorry. Okay. This is Janine Busto.
Nice to meet you all. Thank you so much for coming. It's very warm, so I appreciate all of you here being here today. You'll get a lot of wonderful resources from everyone here. Lifestyles has been in business for 30 years. We're in our 30th year. We provide wonderful services with a warm heart. We have a great team here at Lifestyles. You'll hear from our other team members, our directors that are here today. But thank you all for coming. I'm sure you want to hear from them because I have much more valuable things to say. But if you need any information, I'll be here. Our team is here. Ask any questions. Thank you.
Okay. Yeah, we're trying to just limit the speeches so this way we can get right to what we need here for, which is very important. I also want to introduce, she can just stand up, Barbara Bishop Lewis. She's in the back. Where is she? Oh, there she is. She is our Chief Operating Officer. I want to introduce you to Jamie Turris. Jamie, can you come up a second? Jamie Turris is the Director of Waiver Services, and this is a person, if you want your child in any of our respite programs, which are phenomenal, she's going to tell you exactly what they do and how fabulous they are.
Hi, good afternoon, everybody. Thank you for coming. So, as the Director of Waiver Operations, I oversee several of our programs, including our respite program, which offers programs after hours, after day half, and on the weekends to do things like movies, bowling. We do trips on Sundays to go see theater shows. They're going to the Somerset Patriots game next week, and they do a lot of different fun activities. We also have our supportive employment program and our community-based pre-vote program. And that's for adults who are ready to possibly move into the employment area. They can join the community pre-vote program, volunteer out in the community while building job skills and developing all of those tools necessary to be successful when they do get a job. I do have my card with me, so if anybody is interested in any of those services or has some questions, I will have the card in the back. Feel free to grab it. Thank you.
Thank you, Jamie. Appreciate that. The next one is the Director of Intake Services, Annette Rhea. You have a minute? Okay. She's also, like I said, monitoring the Q&A on our virtual Zoom attendees. And she's also actually helped me, my right-hand man on this. So thank you, Annette, for that.
Hi, just want to say hi and welcome. Any questions? You know where to find me.
She's busy. She does intake for rehabilitation. Rehabilitation. Okay. So I just also want to throw out to you that after this, and the reason why I did this was so that you can get the answers and get the information that the circuit court team is going to give you. There's a lot, believe me, there's a lot of information. Your head's going to be spinning afterwards. And what I wanted to do this prior to the workshop that I'm hosting on August 6th. And I gave you a flyer, and there's a card there. If you're interested in joining us in that workshop, you must hand in that card and check yes or no. Okay? And that's going to be held Tuesday, August 6th. It's going to be at the Lifestyle Stability Center. This is going to be to help families with step-by-step information on how to complete the guardianship paperwork. And again, if you're interested, please again, fill out that paperwork. So without further ado, I'm going to introduce you to the surrogate court team. Okay? Actually, I'm going to let them introduce themselves. How's that?
Hi, I'm Trudy Dixon. I'm one of the clerks in the clerk's office. I'm Trudy Dixon. I'm a clerk in the clerk's office in Surrogates Court. I'd be one of the first people you might come in contact with when you're filing for guardianship.
That was Trudy Dixon. She's a clerk in Surrogates Court. She is one of the first people you talk to when you hand your papers in, is what she said, pretty much verbatim. Good morning, my name is Angela Conti. I'm a court attorney referee. After the paperwork gets past Trudy, can you guys hear me now? Yeah. Okay. So good morning, my name is Angela Conti. I'm a court attorney referee. Myself and another gentleman who's not here by the name of Rob Seuss review the paperwork in finality, and we basically hold the hearings and make a recommendation to the surrogate. Who you missed on the corner from the end here was Trudy Dixon. She was the court clerk specialist. She and her team review the paperwork when you first hand it in. So if you're making phone calls or you have questions or you walk in, you're likely going to speak to Trudy or someone who works on her team. And then I will hand you over to Mr. Sriracha.
So can everyone hear me? That's good? Okay. So my name is Ron Sriracha, and on behalf of the Surrogates Court of Richmond County, we would like to thank first Rita Buetti, who Ms. Buetti is the director of the after-school program for Lifestyles, and also two of the principals from Lifestyles, Richard Milanati and Janine Fusco, the director and deputy director of Lifestyles, and also thank the IBR for this particular space. I have to send my regrets to all of you from Judge Titone. Unfortunately, he got stuck back with a conflict. He had to handle a particular matter in the court that needed his presence there. So my apologies, but we promise we're going to hopefully live up to the hype that you laid out here. And it's so nice to see this many people here today, because I have to tell you on behalf of myself, I've been in the court system about 41 years, and my two colleagues are very modest, but Ms. Conti has been a court attorney referee, but also she managed many matters in the family court prior coming to the surrogates court, taking care of the administrative judge of the family court, going over issues regarding child care, foster care, custody, many difficult emotional issues. And it's really great to have Angela join us, because she comes over to us with that component now. She's able to do hearings and manage cases before the surrogates court, specifically 17A, which you're interested in. And also, the lady to my left is Miss Trudy Dixon. Trudy's been in the system, I think, 35 years. I think she was 14 when she started or something, 12 or something like that. So it's really a pleasure to be here. And you know, the thing I have to remind you of is you guys are the heroes. You're dealing with this every day. You're managing your families, taking care of all your children's needs, your spouse's needs, your parents' needs. This work, this stuff is easy in comparison to what you're doing every day. So we will get you where you have to be. But the first thing I wanted to talk about is exactly what is 17A? Well, when did it come about? When did this particular statute or guardianship law come about? You know, in the late 60s, early 70s, the legislature of New York State saw that there was a great need for people to manage individuals who turned, or for individuals who became 18, because, you know, as you know, in the state of New York and throughout the United States, the date of or age of majority for an individual is 18 years old. So at 17, they're considered an infant. They can't make decisions on their own behalf. And many agencies like hospitals and schools, they look to the natural guardian or the parent to make decisions on behalf of the infant, the person under 18. So there was a big need to manage specific issues for persons who couldn't manage them on their own in the late 60s, early 70s, and that was really in tandem with, if you remember Willowbrook, the Willowbrook School, and Geraldo Rivera had done a whole expose to expose the school and things were not properly done there and persons weren't being taken care of. So many of those individuals were wards of the state, so they needed to develop a quick process. That was simple, but one of the things that this process did, it took all the authority or all the rights of the individual, the person who was turning 18, away from them and gave it to their guardian or parent. So now, a snapshot, 40, 50 years later, there are special groups, because as you know, no one is, we try to look at every case in a specific way, on a case-by-case basis. So when Angela looks at a matter or comes into the clerk's office, we want to make sure, number one, you're in the right place. So we don't want you coming here for an elderly adult who has Alzheimer's, or someone who has dementia, or someone who is taking care of a part of their needs, but unfortunately cannot manage some of the fiscal or other items of day-to-day living. We want to make sure you're in the right place. So we fine-tuned that, and I think that's what Judge Titone was most concerned about, because he had said the worst thing he wants is for you to deal with your day-to-day activities and run around and plan for your family and make sure your child is well cared for. Come into court and you wait 6, 8 months later, and we look at the case and we say, well, unfortunately, you have to go to Supreme Court, which is Article 81, which is another type of special guardianship for another type of, developmentally or intellectually disabled person. Another thing Judge Titone did, which I want to, for your director, Rita, she had mentioned that there's going to be a workshop coming up in August. And I don't know what the hours are, but please keep us aware or apprised of that, because I think the most important thing, Judge Titone, and my colleague Angela had mentioned that this would be really, I think, beneficial, is to have a clerk or a member of the court maybe go to the workshop, so when you're going through the questions, and again, you guys have combat experience. Don't be overwhelmed by this form. We see it all the time. Once you've done 2 or 3 of them, you can do them with your eyes closed. So don't be frightened by this. But one thing Judge Titone has done is he's made sure that staff members come out to these programs, because, I talked about, I've been in the court system 41 years, and you know what? After 41 years, you're looking at papers, and you're doing this perfunctory stamp, and you sign it, you're putting one paper from here to there, and after a while, it becomes second nature, but you do lose, it's human nature to lose the concept that there's a family behind this, that I have a death certificate or a birth certificate or whatever the person I'm dealing with is a human individual who has the same problems I have, and sometimes more difficult problems. They have to wake up each day and be a productive member of society. So I think we lose that, and what he has asked new employees that have been in the system a long time, come out to these programs, meet the people, know that there are families behind the files, as well as we deal with adoptions. We also do estate matters, and you lose the concept that people have lost a loved one or they're managing a difficult situation in their lives. So those are some of the newer things, but to get back to 17A and the history of this proceeding, so you all know you're in the right place. The statute was written, and another thing Judge Titone reminds us of, it was written to give full authority and rights to the guardian, but yet the person who's the ward doesn't have, has probably less rights than a person who's incarcerated in prison. Again, they won't be able to choose their educational, their intellectual or behavioral places, their social gatherings. They won't be able to choose even sometimes the foods that they're allowed to eat. And so after 50, 60 years, there is a heavy movement in the New York State Legislature because they're looking at Article 17A. And what they did back in the late 60s, early 70s was to make it fast, easy, simple, and an all or nothing type of guardianship. But now there are so many nuances in this world. There's autism, there's cerebral palsy, there are persons who have neurological impairment that they can manage. Some of them do go to work. They have productive lives. Some people with autism are making plans to go to college. They want to get married. So there are contingencies or agencies that are looking to, at this point, take a deeper dive into 17A and say, is it really an all or nothing? And they want to give the court the ability to review each matter on a case basis and maybe make it a little bit more tailored to your individual, your person, your loved. But let me tell you a little bit about 17A. Again, intellectual disability. I'm going to use a term that's really no longer bandied about. It was a medical term many years ago, a person who had Down syndrome. They banished the word mentally retarded. They do not use that word anymore. The legislature and also the federal government now uses intellectual disability. And there's also individuals that are paired with that intellectual disability for a person who is developmentally disabled. And again, the statute's clear on what groups those are targeted for, and they are persons with cerebral palsy, epilepsy, neurological impairment, autism, or traumatic head injury. There are people who can have autism, but does the autism affect their intellectual development to a degree? And the catch-all phrase here is that they can no longer understand the nature and consequences of their decisions. So if they're, God forbid, they break their arm, they're 19 years old, and the doctor's examining them, and the doctor wants to go further examinations or, God forbid, perform surgery, would they be able to communicate properly and process the information that they really need to have surgery? They broke their arm, it's not going to heal unless you perform these medical items to the individual. So kind of that gives you an overview, but the good thing is when you do come to our court and you have the papers filled out or you do have specific questions, we're going to try and talk and to see if you're in the right place. Because there's a whole other host of special guardianship for adults in Article 81, and that's in the Supreme Court. And that's maybe for people who do need a tailoring of their guardianship. It could be a person who is got some mental or physical disabilities that may not affect their total world and whether or not they can make decisions or not. So that gives you just a broad overview. I'm going to turn you over a little bit to my colleague, Angela. And again, Angela is very modest. She has a tremendous background in the emotional family portion of this, and also now is assisting us with the management and the hearings. She conducts hearings on behalf of the court that has you make your application before the court. She'll talk to you a little bit about the hearing process, how that has changed over the past few years. And the petition, with the workshop, with Rita, with the clerks, with our information that we'll make available, there is no way you're going to mess this up. We'll take you through, again, step-by-step process. Now, everybody has their own nuances. They may have their own difficulties. You don't know, you may have a situation where your family's not all located in the same area, or you're caring for a person who's in another state. We can look at everything on a case by case. So don't get discouraged. Again, the persistent person is the person who's going to be able to manage this thing. Do you need an attorney? There are so many people especially with the court that we have now, the people that we have in place that are able to do this. Do you need an attorney if you're going to plan to leave your child a large sum of money, or your child has come into money? I would say definitely yes, but we could get the basic application done, the guardianship of the person, which is so important when you're doing, when your child is reaching the age of 18. Another thing you may ask yourself, oh, my child's 25 or 30, I blew it. No, you didn't. I mean, there are people, I've seen people make applications, 70 or 80-year-old people make applications on behalf of their 55-year-old children. You didn't blow it. The good thing is you didn't come up with a situation where, God forbid, there's an emergency and you're in Disney World, and somebody breaks a leg or gets sick, and you're in a hospital, and now the doctors there don't want to give you the authority to make a decision on behalf of your child. So you didn't. If the child is 12 years old, we think that's a little early. You wanna move towards 16 or 17. Why? Because development, happens at its own pace and its level. So if a person came in and said, my child's 13, who knows? With the Lord, with medicine today, who knows what's going to happen? Things could change, and they could develop, they could move forward. Maybe they weren't developing as quickly as the other children, but they could move forward and get the ability to live a productive life and make decisions on their own. So at this point, I'll turn it over to Ms. Conti. We're going to be here for the period, so if you have general questions, if there's questions on the Zoom, we will take them. We're happy to answer them as best as we could. If you have a personal question that maybe you don't want to put out with the 60 or 100 people, especially on Zoom, you know what? I will make my card available. I'll give you my phone number. You can call. We can go over that one-on-one either today or off on the side at another time. So you don't have to, again, ask the question. Fingerprints, Ms. Conti will talk to you about that. People get a little sweaty when they know they have to get fingerprinted because they think, well, what happens when I'm 16 years old and something happened, whatever. We're not really concerned about that. The judge really knows that you're the best person to manage your children's lives and take care of your children. So if there's something, because sometimes we'll see a person come up to the fingerprint portion and then we won't see them anymore. And unless they're, unless they're a one man or woman crime wave like Al Capone, I don't believe there's going to be a problem. And again, we look at fingerprints from the point of view if you're also managing money, because this application is for the person and the property. Sometimes if you have property going to your child, you have to manage the money on behalf of your child. So, again, without further ado, Ms. Angela Conde, who's a court attorney referee for the Surrogates Court, who you may see when you have your hearing, is up next.
Okay, so coming off what Ronnie said, I'm not really sure where to jump off because you covered the majority of what you need to know, but I'm going to start with the last thing that he was saying, which is that this petition is for person and property. Let me tell you right off the top, if you're looking for property, is any sort of property that your child has, for person you don't necessarily need an attorney. For property, we always recommend that you get an attorney. The reasons that sometimes you need to do a supplemental liens trust. Some things that you do may interfere with your child's rights to collect money from the state, their Medicaid, their Medicare. So if that's an issue right away, you probably want to just start by seeing an attorney. So just knock that out of the box to begin with, okay? Coming here now? Okay. Okay. Would that be yelling at my children at home? Yes. Okay. The next thing, so Ron was giving an overview of where the statute is now, and he did mention a little bit that there are some changes now. People are going around to change the type of guardianship that the 17A is, meaning to make it less restrictive. Just to clarify, at this point, that is just something that's being tossed around. If you are applying for a 17A guardianship of your child, you are applying to take away all their rights. It cannot be tailored, it cannot be modified. We get the question very often. Can't be you just make their financial decisions, cannot be you just make their medical decisions. That's not the way the statute is written. We as a court have no ability to do that. It's against the law the way it is written now, so the full guardianship is that you make all decisions for them. Having said that, if you have a child who's autistic, maybe midway on the spectrum, before you do this, you may want to call us and ask to speak to someone and give a little bit of a scenario saying, listen, my child can take the bus by themselves, my child can cook dinner by themselves, they can count money, more likely than not, this is not what you need. Now, I'm not saying that don't call us and ask the question, but I'm just saying that there is now a trend, and our surrogate firmly believes that if your child is somewhat independent in certain skills, that we're not going to likely take away all their rights at this point. So, because as Ron said, this would be akin to being in prison. Not good to that. If your child needs it, they need it. However, someone who can make all the decisions doesn't necessarily need someone else to make decisions for them. So to jump off from that, what do you do at that point if you have a child who can't make medical decisions but goes to work? There's a couple of things you can do. There's something now called supported decision making. I don't know if you've had any programs on that. Have you done anything on supported decision making? Okay. So supported decision making is not run through the court system. It's something you can go Google. It's supported decision making. It's a not-for-profit. They're based out of Manhattan. What they do basically is they sit down with you, they sit down with your child, and they come up with a contract of decisions that you're going to make and a contract of what decisions your child is going to make. Okay, so that's something that you might want to explore if you feel like off the bat that your child would not qualify for a 17A. It's something that we may send you to if you call us and we feel able. So it might be something you just want to look into at this point. The other option is you could speak to an attorney about powers of attorney. So you can get a power of attorney to make financial decisions. You can get a power of attorney for your child to make medical decisions. Again, something if your child is somewhat independent without going for a 17A. That gives you the ability to make sure that you can take care of them, but that they can also make their own decisions to a certain extent. Okay. The second thing that Ronnie pointed out is that while you don't necessarily need an attorney, there are, you can how much is the $3,000? OMWDD? Or PWTD has a program where they reimburse up to $3,000, I believe, annually for either legal fees or for activities, I believe it is. Okay, so Jackie knows about that. So you may want to talk to her about that if you don't feel comfortable now proceeding with an attorney. Or if you're going for personal property, speak to Jackie because there is money available to people. Okay, now coming off of that, let's look at the form. It's a big form, like Ron said. The majority of this form is just, cursory information. It's your name, it's where you live, it's who was in the household with you, how old you are, if you're married, who you're married to. It's like the majority of these forms are like sitting in a doctor's office. They just want to know all your information about you. You scribble through very quickly and then realize nobody can even read what I put down. But make sure we can read it because we do need the information. So that is the majority of the petition. What I'm going to point out to you are a couple of things on the petition. On page, I know you all have it in front of you. So page 5 and 6, where it talks about who's going to be the guardian, who's going to be the standby. Usually, it's both parents come in, they come in for co-guardianship. But then what happens after that? We're all going to pass away, unfortunately. Accidents happen. So we highly, highly recommend that you speak to somebody about being a standby guardian. You can do first, second, third. There's up to 3 standby guardians that you can put in place. This person has to be an adult, so they have to be over 18. So if you have any children, if they're not 18, they cannot yet be the standby guardian. However, this is something that can be modified as time goes on. So if you want to speak to a relative, sometimes it's the neighbor, aunts, uncles, let them know because they have paperwork that they are also going to have to fill out. But we highly, highly recommend that you do this. The difference is, something happens to you as a guardian, if you have letters, which is what you receive from us at the very end of the guardianship saying, I, Angela Conti, have guardianship of my daughter Sophia. And then it would say, Ron Surrattio is the standby guardian. It's all on this form that is available to everyone. If Ron Surrattio is the standby guardian and I have a car accident, he can come into the courthouse, fills out one sheet of paper basically. At that point, he will be fingerprinted. And if everything's kosher, he's going to move up and be the guardian, and there's going to be no lapse. There's going to be no long delay. If I be the standby guardian, if there's no standby guardian, I have a car accident, my child is left without a guardian until this entire packet is done again. Okay? That means starting basically all over again. So if this takes 3 to 6 months, your child will be without a guardian for 3 to 6 months. Does that make sense to everybody? Okay. But you should know, and we remind you again at the time, but when you ask the standby guardian, let them know that they have a standby guardian, and you just have to make them aware that they need to come into the courthouse within 60 days. 180 days, okay, to move themselves up. Okay, everybody with me on that? Sorry.
180 days from my impact.
Yes. Okay, now, the next question we have to get on that is my other child is 16, I'd like them to be the guardian, but they're only 16 years old, so what happens? So right at that point, ask a different family member, ask a different friend, because you can come in when your child is 18 years old, fill out a different form, very short form, and we will amend your letters, and your child can then be the standby guardian, okay? So don't leave it saying, I don't have anybody at this point, I'm going to wait till my other kids are older, because it can be, you can change the standby guardians. People have fights, people stop talking to each other, people move away. That is pretty common that we change the standby guardians. Okay. Alright, so that's really our petition, the main thing that I want to point out to you. I'm going to go through the papers and jog my memory. Okay. Property. If you are only receiving Social Security for your child, that's the only property that they have, you do not have to file for guardianship of the property. When you file for guardianship of the property, the court becomes sort of a co-guardian with you and your child and the money, and that's basically to make sure that the money is not spent erroneously, that you're not going on vacation with your child's money. Unfortunately, this does happen at times. If it's just the Social Security money, that's fine. You can remain as the guardian without the court needing to intercede on that, okay? Bear with me as I go through and see what we need to say. Okay. The next question as we get to combined oath and designation. All the forms that are in here, you're the guardian, as you flip through them, you'll see there's a waiver, there's a combined oath and designation, there's an affidavit of proposed guardian. Every guardian needs to fill out these forms, okay? So it's gonna be you and your husband, you're individually each filling out the form. Don't fill the form out together, don't fill it out jointly. The only form you fill out jointly is the petition. The other forms get done individually or they have to be returned to you. Not at our discretion, this is what the statute mandates, okay? Okay. The affidavit of the proposed guardian. This is the form where it's going to ask you basically, why are you qualified to be the guardian? Don't take it personally, again, these are statutory mandated forms. And a lot of times it's not parents coming in, sometimes it's an aunt, it's an uncle. However, we prefer to look, not to provide your decision, but we do look at it, like you said. You do have to have a criminal background check. We do run to make sure there's never been any ACS involvement. That's what this form is trying to get at. So be honest on the form, because we are going to find out anyway, okay? When you run into problems is when you're not honest on the form, and then we get back, oh, well, we might have had an ACS case, but we forgot. Or I forgot I got arrested, 4 years ago for a DWI. That doesn't necessarily mean that you're not the person to take care of your guardian. However, if you're lying to the court, it then puts you, the court's going to look at you a little bit differently, and they're going to wonder, why are you lying? So just be honest on the form, okay? The most tricky part for all of you probably is to get the affidavits from the physician and the licensed psychologist. Again, this is not something that we have leeway with, and I keep saying that because a lot of times people want us to waive things. We cannot waive things, it's not our option. The affidavit from your doctor is just going to be who your child's been going to. That usually is a quick thing. The doctor signs it for you. It's not a big thing. It's usually the licensed psychologist that takes a while. I'm sure Jackie and Rita can tell you. Right now, to our knowledge, there's a 6-month waiting list to get these forms filled out because they have to do the whole, they do a whole assessment, and we get the forms of the assessment attached to us. And these two particular documents have to be no older than 6 months when you hand them into the courthouse. So it's not something that you want to start now. So maybe when your child turns about 16 and a half, you might want to call and make sure you're on the list to get these forms done. Okay? Without these forms, again, there's nothing that we can do. What we can do is, if you've had your doctor fill out the form and you're now on a waiting list for a psychologist, you can partially file. We don't like it, but if you have some of the forms ready to go, you can partially file them with the court, and we will hold the file open so that they don't go stale. It has to be filed with us within 6 months. So if there's a 7-month, 8-month delay between the forms, that's fine, as long as it's been filed with the court within 6 months of it being signed. All right? Yeah.
Just a couple of things as Angela is going through the forms, not to confuse you, but most of the times people do come in for guardianship of the person. And that's, again, to manage the support, the health and welfare of your child, to make decisions, whether it be schooling, medical decisions. It really takes the place of, for example, if I'm guardian for someone, and as we get older, my wife and I will have a healthcare proxy, we'll have powers of attorney, so it is something natural that occurs in life. It's just that you're doing this a little bit earlier for your child. I always tease my wife, and I'm quoting Judge Fuster, who used many, many years ago, was a surrogate, he used to go around and say, if you're going to pull the plug on me, give me at least a week or so. Give me a fighting chance, because I may come back. Don't do anything. And, it's something that we all have to face in our lives, that God forbid we become incapacitated, that we have a reliable human being. So, guardianship of the person is kicking in a little earlier. It's kicking in early on behalf of the individual, but it's something that as we age, as parents or responsible adults, we're going to have to figure this out for ourselves and maybe look to other people, because we ourselves may become incapacitated at times. So it is something to think about for your own future as well. And that turns me into the next thing. This is guardianship of the person. If your child has money in an account, already money received, and they're getting government entitlements, you probably want to go to an attorney and talk about guardianship of the property, but more importantly, a supplemental needs trust. or different types of trust that still allow your child to get the resources from the state and the government, but it will allow you to have money for them for their care and benefit. There are all kinds of products today. There are supplemental needs trusts. There are trusts that we as individuals, as we age, we have to create a trust on behalf of our family or loved ones that we would like to leave running, or create a will. So these are some important things that you probably should approach. One other question I wanted to get back. I think in my history in the court, and Trudy and myself have been in the court such a long period of time, I think the good thing about why you're all here, the best thing is this court is equipped with staff, the right judge, to manage your cases to the best of their ability. In the past, I would go back the past 40 years. Years ago, you know, attorneys, staff people were always a little afraid to get too involved in your life because there was always, you know, we live in a litigious society that if something goes wrong, well, the court told me to do this, or they were involved in this petition. You know, the judge will do as much as he can do. He will educate, he will inform you as best as possible, and we will process your application as soon as possible. Like I said, years ago when they had the statute first developed, I can remember hearings being held in the court, and they were almost a rubber stamp. So in other words, we got the petition in, and the parent and doctor said, there's no real reason for the disabled individual to come to court. It would take them out of their structure, they may find it's gonna blow their whole day, cause an emotional issue. So we would encourage the petitioner and the doctors to say, yeah, the necessity of the ward being present during the hearing is not needed. And we would conduct a hearing based upon the doctor's reports, never see the ward, never see the interplay between the parents, and we would issue guardianship. We would take rights away from this person. Now, there's a movement 50 years later, like we talked about, that they're looking and examining different things. There are groups called Disability Rights of New York and other agencies that are very pro-disabled. And they're pushing for a change. They're saying what happened years ago really wasn't correct. We have cases before the court where people received guardianship and they were, you know, there were doctor's reports, but these people then went on to lead a productive life. They really didn't need guardianship. So there's a lot of things going on, but I can tell you one thing. The people that you have in place right now in this court are probably the best people I've seen in the past 40 years. And that's not a criticism to the people who did serve prior. It's just that we know more. Now, and Angela will talk to you about a hearing process. Now we're going to step into your home with the use of technology. And you're going to be able to conduct a video hearing that hopefully will not take your child out of their structure, whatever their program or situation or life is. And we'll get to see you. Your child will do the same things we would do without the ward being present. And we will issue the appropriate authority. So again, I think, when you look at it and say, oh, I should have did this 20 years ago, you know what? You're doing it at the best time for you and your family, and the best time for the court, because we know more, we're involved more, and again, these things don't get done, nonchalant. They get done with a real close look at what's going on with your
ask the question, how many rights are you after all years ago, you have to hire at least a guardianship to save the parent. You know, we want to still see our we want to still see our child free, not be completely,
Well, that's why, at this time in history, it's being documented and recognized that, again, the statute that was created 60 years ago was based upon something that they needed quickly, that there was a reasonable need for, and this process, the great thing about this process is it's quick, it's simplified. If you went through an Article 81 process in Supreme Court, you may need the assistance of a court evaluator, an attorney, the assistance of the court. They needed something that could perform a function on behalf of a specified population of individuals, specified by the statute. What this legislation didn't do was recognize the nuances and the differences, and that's what Surrogate Titone and Angela Conti are talking about. Supportive decision-making sometimes could be a committee. So in other words, the parent and the child agree on a committee of people, which could include the parent, the child, an aunt, a parish individual, somebody who's involved in the schooling of the child, and you make decisions as part of a committee or group. But we would look at it from that point of view to see if you meet the statutory requirements of an all or none. But one thing the judge has done too is, in the past 5, 6, 7, 8 years, he's tried to tailor a particular guardianship based upon the individual's wants, needs, and family situation. So he recognizes that, even though the statute doesn't, the judge is trying to recognize that. Yes? Yeah, we can get questions, sure, and I'll let my colleagues answer.
Can you stand up, please?
After I fill out these papers, do I have to make
You don't. But, you know what? If you do call us and say, I'd like to come down Monday morning at 9:30, the good thing is we will be expecting you. We have help centers. We have availability for people who come off the street. And when we know you're coming, it makes it a little easier upon us to say, oh, the young lady and her family are coming at this time. I'm not gonna see, and if somebody comes in off the street, maybe I'll say, we have an appointment, I want you to be patient as possible, but let's finish with this person. So it is nice to make an appointment, but it's not necessary. You fill them out? You can call me, I have my number here, and we can set up an appointment, or you can come in tomorrow morning. When you say you have the papers, you have the petition, the doctor's reports.
the evaluations, everything? Okay, when I get that.
Yeah, we want you, and the reason is you come in with the petition and try to do, and I'm not saying piecemeal is bad, but if you do the petition without the doctor's reports, it's gonna make it hard for us to say to you, we read your report and we had a member of the law department, whether it's Ms. Conti or Mr. Seuss or whomever, who's gonna sit on your case. And I don't know, I have an allegation from the petitioner saying we need a guardian, but I don't have medical documentation to indicate the level of capacity of this person. So it's good to have at least a petition, a birth certificate that we know a person's been born and that they live here on Staten Island, and the doctor's evaluations.
When I confuse you, when I said we'll take the piecemeal, when I will take the doctor's piecemeal, but you should have at least the doctor, at least the psychologist, because otherwise we cannot really review anything and say that you're in the right place.
So can I file myself or do I have to?
No, you can file it yourself. Everything has to be the original. I know a lot of people think we can do electronic, the way the statute is written, it has to be the original documentation. Just as an aside, there's a $20 filing fee that people don't realize, so you need to include the $20 filing fee. Another aside, we need an original birth certificate that will not be returned to you, so you can order that from the Department of Vital Records. I think it's $15 to receive that. These are like the things you can start to get in place now, but I did not mean to confuse you, I apologize. You should have at least one medical document when you're handing in the petition, so that we can look at it and say, hey, you're here, or you should be here, or no, you should not be here. Just to jump off on something else that Ron said a couple minutes ago that triggered me. If you're here and your child is already over the age of 18, that's fine, we all can see that. You want us to get working on it, ASAP basically. If there is an emergency that you know about, if you're in the ER, you can't call us and we can't issue you letters. However, if your child needs to have some sort of surgery and it's going to take a while to get all this together, you can contact us and we can try to work with you to give you what's known as limited letters, which may allow you to the authority to get the surgery in that limited situation. So if you're in a situation like that, you need a little bit of notice. Again, if you call us from an ER, we can't help you because we don't know who you are. But if you know there's something coming up and your child's already over the age of 18, reach out because there may be a way that we can help you while you start to get everything together. And just one more thing I just want to let you know. The other thing that does take a while, just so you should be aware of, and what probably takes the most time, once we have all the paperwork, we have to send away for an ACS check, Administration of Children's Services. It's a form that's on here, it's probably the most complicated form, just because it gets sent to another agency, and like all agencies, if it's not, dotted exactly the way they want it, it will be returned to us and we will return it to you. However, the response to this form is now taking up to 3 to 6 months. So that means once you get the paperwork into us, even if we are ready to go on our end, we cannot go until we receive back from ACS their response, okay, just to let you know. So there is now a little bit of a delay that's been happening. What's your question? Well, the differences are in guardianship that all rights are gone. So you're going to make all your child's financial, medical, social, what they wear, what they watch on TV, where they spend their day, what they spend their social security on. Supportive guardianship, supportive decision making. That's what it is. Not a court agency, it's done with an outside non-for-profit agency. However, they tailor and they work with you. So you need to have a child who who's higher functioning on their disability and is able to maybe make a financial decision that they can go to work, and then they'll decide, Mommy, I want to go to work, but you keep my bank account. That's an individual tailor that we have nothing to do with, that is done through a different non-for-profit agency. 6 months until they're filed. So they have to be from the date that they're signed, they have to be filed with the court within 6 months.
I had started to fight guardianship from the 718. I went to started court. I spoke to a local court clerk who actually had said to me his IQ was like just there, and maybe I learned to wait a minute. Because we can't get it back. So now he's 42. And he wasn't passed away last year. When we were doing the will, I had an attorney do a power of attorney for me so that I could make medical decisions before I could make financial decisions. But when it was time for her to present it to him to submit, she wouldn't sign off on it because he didn't understand what he was signing. So in that case, I'm right to be going into court. Right?
I mean, we can have a side conversation about to see exactly what his other,
That's the first one.
to see exactly where he is in other places. So we can have a sidebar conversation about that.
Okay. Anybody else? This is a combination of the sale. One of my first questions that I wrote was how do I know if this is right for my son? He's high functioning. He just graduated from general high school, public high school. He turned 18 not long ago. So, from what I'm understanding, he do what he does. He's independent. He does laundry. He goes on the bus. There's stuff and all. I'm trying to think. I'm starting to think. I'm starting to think for my son. And do you have a checklist per se? And I know you guys are speaking about it. But is there a checklist that I can go, oh, Marcus does this, and Marcus does this, and
I'm sure you can see that number of documents, reports, evaluation.
yes.
And we tend to think about what the doctors believe, but what's his next steps? Is he looking to go into a vocation, into a school?
Currently taking out courses. So, yeah, he's no, he was actually in the same way that he He could take the bus and the train, yes.
So later than that.
Is that what? Yes. Thank
With
you very much.
those supportive as time goes on, sometimes we want to look at supportive. When you as a parent, I'm sure, have to make a decision on behalf of your child. If your child wants to do one thing, the parent wants to do another. And I'm an adult, I don't want to do this. Sometimes supportive decision making creates kind of get a little bit of a group together to see what's the best interest. To put another opinion in.
What is that?
Decision making. Yeah. Google it. There are agencies.
Okay, thank you. Supportive decision making.
Yes.
Thank you so much. Well, I know. And they don't object to the doctor services, they're not good, right?
How old is that? They're 20 years old. Right. But we don't know, when I can't, a lot of times if I break my arm and I'm in pain and somebody comes in who I've never met before, and although they have a white coat on and they start pulling my arm around, and, I may pull away and say, no. So sometimes, they may look to an authority, a person, especially if they're not capable of verbalizing their consent, they may look to somebody who has the authority to make a decision. Now, there are some hospitals, again, the hospitals are concerned from a legal point of view, but there are some hospitals that say, okay, your mom, and all right, we're going to have to take you into surgery to repair that one. And they may go along with it. But there are some doctors who make sticklers and may say, I don't, unless you can give me a verbal consent signature, I don't want to perform the surgery. I feel that the hospital doesn't have the authority to do so.
The main reason why.
Well, it also placement of schools, have they reviewed, for example, as you become a young adult and you want to go for higher learning or go into a vocation, whether it be plumbing or electrical, you're capable of entering those places and making an application and joining in with the decision with your parents as you become an adult. Are they starting to indicate that their preferences? Are they able to do that?
One is, the other one not so much.
So maybe you have to look at what the doctor's evaluations look like and what, if you're meeting with the court, what our recommendations could be.
Older, it goes into a group home. Group home doesn't have to speak with you because you're not the guardian. You want to go to the bank and endorse a check. The bank's not going to let you endorse the check. So there are other reasons why you would obtain guardianship than just the medical. So you have to think about your daily long-term life of what your child may not be able to do for themselves that you're going to have to step in and do, and see if a third party is going to allow you to do. That's sort of the question I'm actually answering.
So at this time, I have no intention of putting my family in a group home. However,
You can come in at any point. The decision to file or not file is solely up to you. However, in an emergency case, just to be aware, in an emergency basis, the court may or may not be able to assist you like that. That's kind of where we're at.
You get a call from somebody from Staten Island University Hospital, you're reaching on Staten Island, the judge, they'll know who the judge is, they'll indicate, represent the court, and the judge is saying, let me fax a quick order over to you, saying, mom has the authority. But if you're on vacation in another state, they may not be able to understand or acknowledge, Judge Matthew's tone and what the Southern Report does, and they may say, we want something to raise still. I don't know who this was.
but if say one of them did doctor did what they're on, and they were okay with the doctor
what the hospital and the hospital staff wanna do. But I don't mean to be disrespectful to you, Amanda, I don't know what the hospital will allow you to do at that point. That's gonna be up to the nurses and the doctors and their staff.
Probably use the terminology, do an assessment, does the injured individual understand the nature and consequence of their decision? So if they're gonna communicate with your child and they'll understand, you know what, we can do this, and if you do it, you'll have hardware in your arm for the rest of your life, but if you don't do it, this is the child have the ability to understand the nature and consequences of their decision. That's
You
key.
can tell us both experience, but the hospitals work with them and it's never been an issue, and we have people get line in the hospital work.
That's very clear. Okay. But according, like what she's asking, now you said you can get a power of attorney, the medical and money, correct?
When you go to a lawyer, and a lawyer will assess, for example, if your child is over 18, this may not be the appropriate application. A lawyer is going to make an assessment like they do for a will or other legal documents. Your child over 18, the age majority, and do they understand the nature and consequences of allowing you power of attorney, because they have to join in. So if the lawyer's assessment, after speaking to your child, is, you know what, I'm not happy with the level of capacity here. As long as your child understands the nature and consequences of it, like a person who's elderly, you bring mom or dad to the lawyers, and the lawyer asks, Mom, who's the president? She says Herbert Hoover. We're in trouble, because the lawyer really, in good conscience, can't make a professional decision to allow mom to sign to give you the authority to make a decision.
It's up to the lawyers.
Well, the lawyer has to do a professional has to do an assessment when they do a power of attorney, a durable power of attorney. Does the person understand the authorities that they're giving away in the event they're incapacitated? But that's with the understanding that at the present time, they're not incapacitated.
Well, I do everything that's going on. And I have control of the first set of money. She asked me. And I have nothing, I don't have any power of attorney, but she does it because she works against.
Correct.
So, same with the medical, like when we go to that, whatever, she goes by what I say and all that. So, what I'm saying is, so instead of body, she take all the rights away because she got socialized on her own more or less. The best bet is to go to a power of attorney.
Well, again, I don't think we can make that assessment here. I think you're gonna need the help of a doctor, get a report, do they have an IEP?
Well,
To see a plan on how they're able to achieve a level of day-to-day activities, and then if you're gonna come to the court and indicate that.
not to the court, the lawyer.
No, but whichever way you wanna go, if the lawyer perceives that individual, especially on point of view, has the capacity to sign a power of attorney, they're gonna make that assessment.
There was a question back there. Miss?
I'm sorry, I have a few. The standby guardian, do they need to be present when the paperwork? Do the standby guardians need to be present when the paperwork is filed? No.
Not when the paperwork is filed, for the are ones that they need to file and notarize that they sign and notarize and need to submit to us.
Okay, but they don't need to.
Guardians do not need to be present in the initial hearing, but they do guardians and the child.
Can we just circle back to the ACS checklist one more time? Is that something that can be found in the packet that you guys distributed? Or?
Yes, or, I mean, I'm sure the 3909, the very last one. Yeah. So you know what, I'm gonna, these clerks.
Yeah, so we're gonna still be here for questions, but I would love for Ms. Dixon to speak to you a little bit.
Okay.
And before we that, we get one more question
And
about.
I'm sorry, just one more, just back to, her question where she said, what do we do when we finally get all our ducks in a row and all our paperwork is completed, is there one main general number that we should call, or do we just literally call you on your business card to set up an
Yeah,
appointment?
you can, there is a general number, if you wanna write it down, it's the
Yeah,
general
the general
clerk's
number.
office, and you can proceed with them by saying, we were at a lifestyles workshop, we had members of the court available, and we would like to come down tomorrow morning at 9:30 to file an application for guardianship. The general number is 718-675-8500. And in our court, you're always gonna get a live human being. Try and stay away from the hours of 1 to 2 though, because they do, people have to eat, computers don't go to lunch. So, one other question, or a couple of questions, and then I don't want you to lose the ability to hear one of my colleagues, because she's been at the court quite a number of years, and she has a broad experience to talk to a little bit as well. Okay. Yeah, and then we'll get Trudy in, and then I promise I won't leave here until we answer every question. Yeah.
So the question is, what is the age of the child? What their child is the child?
Well, between 16 and 18 is when you want to walk in. You have legal custody of all your children till they're 18 years old. Once they turn 18, then you no longer have legal custody. So we recommend you start this procedure 16 and a half because of the wait for the psychologist and because of the wait for the response from ACS.
The follow-up says also, parent carriers of guardianship overwhelmed. If relocation to another state, is it valid? Document without knowing
It is a valid document. It's a court document. It follows you. If they have interstate agreement on all these documents that they follow. Some people, when they move to another state, decide to have that other state stamp it, which means that they bring it in and they file in that court just because they're worried about those hospitals aren't going to recognize an out-of-state document, something like that. But it is a valid document through all 50 states. Okay. And it is for life. Once you receive this does not expire. This is until your child unfortunately would pass away.
No, I was just gonna say, isn't there a YouTube channel with every page
That's what-
Oh, yes.
She's on.
Sorry, I was trying to help you out, cause I was like, you know what, these guys should help
You guys
everybody.
don't need me.
No, you're right, you're 100% right.
My colleagues covered pretty much like everything. I just wanted to add a couple of things. For one, I always recommend that you order a certified copy of the birth certificate of your child before you file with us, because we're gonna keep the document, it's gonna become part of the court record, and I personally do not wanna give up my original birth certificate. Another thing that's really important is, you look at the IEP. If you have a recent IEP, that gives us a lot of information about your child. And then the last thing I wanted to mention is that we know that this is a very intimidating process for you. I personally have a son who's on the spectrum, he's highly functioning. He does not qualify for a guardianship. He does get OPWDD services. So if anybody wants to reach out to me personally about, what I do for my son, he's definitely involved in all of his decision making. He cannot make a doctor's appointment or refill his medication. He cannot travel by himself. He cannot handle money, and he is not qualified for a guardianship. And in addition to that, we do have videos on our website, on the court website, that help you through the process. And we also have a checklist if you go on the website and, print out
Can
the
you
form.
guys give out the website and the phone numbers you keep referring to?
Well, the
Before some of us
website is, if you Google Richmond County Surrogates Court,
Okay.
and then once you Google that, you're gonna go into our homepage. On the left side, there'll be a number of tabs. One could say general information, home. You're gonna click one that says guardianship. And then when you click into guardianship, you're gonna see guardianship for a minor, under the age of 18, because we also do that. not to confuse with 17A. If a child receives money through a state, or specifically a child needs a guardian for the person, for their parent, we manage those things. But there's also 17A or special guardianship. You'll click on that and you'll see 4 videos. And it was broken into 4 parts so you don't have to. And you know, it came about through real difficult situations. Sometimes good things come about. During COVID, one of the court attorneys that represented our guardianship department, she was trying to put together some things when people had questions. So she did these 4 vignettes talking about petition, the forms, and it's really, I think it would be a great idea to look at it, all of it, before you go down the road, because I think they're very, instructional, and they're really complete. So I would choose to look at that before you start the road.
And I just want to add that the workshop that Lifestyles is doing is August 6th. And most of the questions that you're asking here, you can ask there. And if you have anything you think of after today, you can contact me, Trudy Dixon, at Surrogates Court. You just call that general clerk's office number and they'll reach you.
And we will also be showing those YouTube videos that we have spoken about step by step on how to do that.
There's a question from the audience. You want me to repeat it?
Yes.
Yeah, that her son was 100% disabled through the Marines. Now, this section, again, we have to follow the law and the medical evaluations. That gives us the guidance of where we're going. Now, this section talks about traumatic brain injury. Now, if the basis of his disability was, and I'll read right from the statute, was from a traumatic head injury, and that head injury, there's really no requirement whether it was before or after the age of majority. How did he become disabled?
He just born now, he's got a mutation of some,
Right. I understand. So he has guardianship. But where did he get the guardianship from? What agency? What court? Probably Supreme Court. I'm going to guess it's an Article 81. It may not be the Surrogates Court that gave guardianship. You have to go back to the court that originated guardianship and make an application and say the family wants to come forward and we want the agency to back off. I believe it's the Richmond County Supreme Court. Do you have the order or a copy of the order? We could look at it afterwards, where the agency received guardianship from the court. I'll give you my card. You can call me. I'll look to see what court or agency issued the guardianship, and then we'll move from there. But my guess is it's Supreme Court, Richmond County. It may not be our court.
Any other questions? That's there. Stephanie, that's the one.
Well, most likely I'm gonna do the standby guardian. What rights do I have on or do I have
What rights do you have as the standby guardian?
Yes.
None. No. It's the guardians until you move up, correct?
You're like the, when they walk into the pitches in the game, throw really good, and the 8th inning gets in trouble. Physically, mentally, something goes on, you can't perform anything. That's when you're gonna come in. You're gonna be like the closer. Like the relief pitcher.
what forms do I fill out? I think you mentioned it before.
Once the statute says once the guardian becomes deceased or incapacitated, you get immediate authority. So if God forbid there's a car accident and it's the guardian and the ward driving in the car, and they both get injured in an accident, and they're both incapacitated at this time, you can run down to the hospital, and on behalf of the ward, you can say, you need to do A, B, and C, because my mother has guardianship with my father, but I'm the stand. Now, as far as your mother's concerned, that's why I said as we get older, you want to make sure we go to an attorney and speak to them about, in case there's something going on with my life and I get injured or I get a medical issue going on. Who am I going to give my authority to? We want to make sure that somebody can call the shop.
Can an adult child be a co-guardian if they're here for their sibling?
Absolutely, yes. So it's something that you can do.
Just as an aside, just going back a minute, when we were talking about fingerprints, and maybe think of it as standby guardians, anyone who resides in the home with the guardian is gonna be fingerprinted, not just the guardian, so the entire household, over the age of 18, okay, so anybody is in the house, so spouses who are not gonna be guardians, step-parents, older children who are over the age of 18, everybody needs to be fingerprinted, just so everybody's aware of that.
Even if an ex-spouse is living with a spouse, or even if they're living with a boyfriend or whatever, that's their residence, the agency of services wants to know that.
If the standby guardian needs to be changed at some point, what is the process?
You come to the court, you fill out paperwork.
Oh, okay.
I don't know if you answered this question or a lot was going on. Can a standby guardian make a decision if the guardian can't be reached? Like say, me and my wife are away on vacation, my daughter's in her group home in her work program, and she gets injured, and we can't be reached.
I don't think so.
So they,
Because in today's world, it's almost like everybody.
so that wouldn't be, so it could be me, my wife, and somebody else. So it doesn't have to be just me and my wife. It's me, my wife, and a third co-guardian. Right, they make a decision we can't be reached. That could be a co-guardian.
Yeah, the instances the standby statute says if the primary shall die, become incapacitated, or shall renounce. So, those would not be.
Angela, that was good. I honestly didn't know that I could guardianship. I did not know that I could have more than 2 people have guardianship. No, right, but I didn't know that you could do that. That's great to know. Yes.
You were starting to say something about having a video hearing, I think, with the person and.
So Angela could tell you about it.
So once you've submitted all the paperwork and it's been approved by Julie and Ron's staff, it comes up to either myself or Rob Soup with the court attorney referees. We review it and we then hold a hearing. During the hearing, it's going to be anybody who's applying for guardianship, meaning the guardian, not the standby. And we're doing these right now on Microsoft Teams just to make it a little easier for everybody. So it's going to be the guardians need to be present and the child needs to be present. Regardless, you're going to see on the medical forms there's a question here that the doctors fill out and say, do they think the child's appearance should be waived? And more likely than not, the doctor says, yes, they think it should be waived. The court does not waive it. It's mandatory that we see your child for reasons that sometimes, unfortunately, people apply for guardianship for. They not necessarily need guardianship, but sometimes people apply for guardianship for other reasons. Financial, I mean, things happen in the world, so we don't need to go down that route. So we do mandate that we see all the people, okay? And so it's usually about a half hour of a hearing. It's not like you're hearing, it's not your contested hearing that when you're watching Law and Order or anything like that. You know, it's not, nobody's objecting for the most part to your question. Usually myself or Mr. Seuss are going to help you put these documents in evidence if you don't have another attorney. We're going to ask you leading questions, which will never happen in any other sort of court situation. It's a nice, easy hearing. And basically what it is we're going to ask you to explain what your daily life is and what you do for your child on a daily basis. And, you know, literally, like the nuts and bolts. We get up, we make a breakfast. Just because the idea is we want to be able to see how much your child is able to function for themselves. The medical documentation, we've already read all the paperwork that comes in from the doctors. Usually by the time we get to the hearing, if we have any questions about anything that the doctors have written, you would have heard from the clerk's office, because we're gonna ask for it to be supplemented. And we do that for the purpose of, we're not asking the doctors to come in and testify, we're just going based on what you put in. So usually by the time we get to the hearing, it's for the most part, nice, smooth and easy hearing. Myself or Mrs. Seuss then write a report to the judge saying we recommend or we don't recommend guardianship, and then the judge makes a final decision.
Do you question?
We will talk to your child, yes. We read the report, so if your child likes to play on YouTube and listen to, I don't know, Taylor Swift, we'll engage with them about Taylor Swift if they're verbal. Even if they're not verbal, we try to engage, because a lot of times reports say not verbal, and then somebody gets on, and they're like, they tell us the whole encyclopedia on something, and we learn stuff from them, so yes, we will engage. Parents sometimes get worried because my child can't sit still, that's fine. They don't need to sit still for the whole thing. If you have to follow them around the phone just so we can see for a couple minutes, that's fine, we'll work with you. And that's actually why we're doing it from the home at this point, to not put people, like Ron said, to not put people out of their environment. If your child is in a facility, the facilities will cooperate and they sign on, so it's never been a problem. Sometimes if they're in school, they don't want to miss school, some of the kids. The schools usually cooperate and they'll let somebody sign on with the teacher, so it's never been a problem to get everybody on. And we have one child recently, he likes to ride around in cars, so we did it from the car, so we work with you, it's not a problem.
Yes.
We're filling out the paperwork for my sister. I'm gonna go down as one of the co-partners. When I got married, actually the most that I've done, and my name is changed, so I have to go and file anything, or?
What you should do is, after are you engaged, congratulations.
No.
Okay. Well, you may want to rethink that also. Okay. What you're gonna do at that point is you're gonna send us a copy of your marriage certificate, of your new license where you changed, and we're just gonna change the paperwork.
Okay.
It's a simple thing.
Husband and wife have both. It's the marriage.
No, it's whatever situation you and your family feels work for you. However, you cannot get guardian, if you're divorced, you cannot get guardianship of your child without your ex-spouse knowing about it. Okay, it's still different.
The question the gentleman asked about that, if you name,
If you name a person as and they're a fiduciary to be the guardian of your child, just make sure that the person is authorized to serve in the state of New York, if you live in New York. And the same thing about an agency. Sometimes agencies have their own charters and they're authorized or not authorized to serve as special guardians on behalf of. So just make sure that that's handed out.
I'm gonna jump back down for a second, of authorization for illegal immigrants. We have people who are not coming in because they're not legal. You should come into the courthouse because you still need guardianship of your child, so the courthouse is figuring out ways to make that work. Okay?
Co-guardian?
no, the standby. They can only, the statutes kind of, you think about why they write these laws, they do make sense. For example, if somebody's in a meeting and I can't make a decision, if I'm a standby, they don't want really two conflicting. The person is in charge until they're not in charge, and they give you 3 instances when they're not in charge. They're incapacitated, they're deceased, or they decide to resign. So they don't want to make, give the standby authority and have somebody else fall down there saying, I wouldn't have did that.
The reason you want to do that is because if you have an accident, you're driving home, you have a car accident, you're the guardian, and there's no standby, this entire packet starts from the beginning. So it takes months to get a new guardian in place. If you have a standby guardian who's already been issued letters by the court as a standby guardian, they come into the courthouse, it's a very simple procedure to move them up.
And that takes 180 days, but in the meantime, if the individual who's the guardian is incapacitated, you have the authority as a standby right away. If you meet those 3 criteria, for the deceased, incapacitated or the person made an application to the job.
I just wanna make sure I understood something you said before. My son gets, social security, because of the state of his son, has been, yeah, social security. That's all he gets, so I don't have to worry about that.
So you're the, sometimes Social Security wants to see guardianship letters from the person, so they can put you as a parent.
Well, it goes into a custodial account,
Right.
so social security knows.
And if they're good with that, that's money that, now, to be the payee, you don't pay. But let's say, for example, that money is accumulated, and let's say, for example, there's now $100,000 in that account. You're probably gonna want, because what's gonna happen is sometimes the banks start to trigger, that this person has assets, and then whatever entitlement they get comes into conflict.
It's not even.
Yeah, it's usually some people use that account as a watch, pay bills, and then to day-to-day.
Yeah, it's a lot.
Yeah.
Yeah, so all I'm doing is. Yeah. I just wanted to add something about the limits, for social security. With the race numbers, I attended, a meeting, and it was on the able account. And the able account, that's for, the people who, they have a plan. And when it reaches 2,000, which is the cutoff for social security, the money will be, maximum will go to this able account. And it's not, and so it's not effective. That's all, the social security money isn't effective. Oh, you know,
It could be as long as it takes for you to get all the paperwork into us. Pretty much once we get the paperwork in, as long as everything's completed correctly, I'm gonna qualify because once that paperwork is into us, once that last form, that 3909 form is in that very next form in the back that we send out to the state for the child abuse record, that's our first hold up. We can't do anything without that. Right now, we're operating 3 to 6 months to return that to us. It used to be a quick turnover a month with, I guess, budget cuts and everything else. We're on a 3 to 6 month delay for that at this point. We're kind of holding to that. Yeah.
Is that an act or fraud? The statute indicates you can have 2 medical doctors. However, one of those medical doctors has to be well acquainted with the care and evaluation and diagnosis of a person with that disability. So, for example, if I had 2 medical doctors, my pediatrician and a neurologist, who is well acquainted with, God forbid I had 2 before, well acquainted with it, that's okay. If you only have 1 medical doctor that's not acquainted with, you get 1 amount. The other one has to be by a licensed psychologist. Yeah, if they're a licensed psychologist, there was a period where somebody was doing these write-ups, and I don't know if they were licensed, and you gotta make sure they're licensed. And I think in the form it says, I so and so, and they license.
We can always get information from other places that you know to get things psychological done, and you have to listen to that, and I can also, I can order that. Yes.
We also have child support enrolled in waiver and impairment. Impairment will help you get those evaluations and help you make them. They'll tell you who has available for what to go.
So if you're already, if you're not already enrolled in the waiver, so get enrolled in the waiver.
And your impairment will help you find those places that are gonna help you
Yes.
with that.
Yes.
That was my concern, just about how to find licensed psychologists, if there's a recommendation, I would like to use that.
If you have a care manager, as Margaret just said, if you have a care manager, that care manager will have a list of places that you can go. But again, I will send all that to you.
Do you know if IBR?
IBR does it. We have a lot of places, places, you know,
your question, if you call the court and ask for recommendations of doctors, we can't give them to you, so we would refer you back to. Yes.
Yes, my son just turned 21 and he got a new doctor. He doesn't really know my son that well. So can we go back to the pediatric to get a...
As long as the pediatrician will sign it.
So it's okay? Doesn't have to be a...
As long as he'll sign it. I just wanted to, we have a form up here, I just want to read the question. Are parents responsible as they would be for a child under the age of 18 when they have guardianship? When divorced parents have guardianship, it's either parent bound by the court to support the child for health insurance or of course housing. So I'm going to stop with the first question. Guardianship, I'm not quite sure I understand the question, but if you have guardianship at a family court, for instance, if you're divorced and you have a Supreme Court order of custody, or you have a foster child, or you have another child living with you who's not your biological child, and you have a family or Supreme Court guardianship or custody order, that again is only good till the child is legal. So that would not take the place of this guardianship. So if you have that order and you have a child who's disabled, you may need to come into surrogate's court to get a new type of guardianship, if that's what the question is. Regarding guardianship and health insurance and housing, if one of the parents refuses responsibilities, is the case treated as a minor? The law has recently changed, again, I'm probably going to refer you back to your divorce attorney, but the law has recently changed that you can collect child support a little longer for children who are disabled. That is not done through surrogate's court, that's done through Supreme or family court, so you would probably need to go back to your divorce attorney to have that conversation. It's not something that we do.
Yeah, I've seen cases or scenarios, for example, of one spouse unfortunately passes away, and they had all the insurance benefits were driven to them, and then the spouse remarries, and the step-parent will come in many times in family court and get guardianship just for the sole purposes of putting them on their, required by their job, putting them on their insurance, the medical or other benefits. So, there are reasons why a person would get guardianship of the person for those purposes.
I know that guardianship is valuable, right? It is what it is for the child. But then, does it apply to the parents? The parents say, well, no, I don't think it's more comfortable with my son.
They can resign.
Okay.
Parent could voluntarily resign, but if you say, my ex is not really where he or she needs to be, and I'm really not happy with that, then you would have to make an application for the court. It's almost like a fiduciary in the state. You would have to show cause why that person would not be the best candidate or to be a guardian for your son or daughter.
Like the parents.
Yeah, so, but they could resign. They could say, some people, we have fiduciaries who get older, parents who get older, and say, we can't manage this situation anymore. I'm too old, I'm getting forgetful, and they make an application to resign, and you can ask the standby to step up to the plate.
So if both parents resign, then there's no guardianship.
Well,
And the standbys are gone, there's no guardianship, right?
yeah, you won't be, it's almost like a burden of a ship. We're not gonna, if that gets into a situation, the court is gonna have to contact certain local and state agencies to bring it to their attention to manage the situation. We're not gonna just allow people, even in the state, sometimes people throw up their hands and say, I want to resign. That's all well and good, but where's all the money? What happened to the state? So we're not gonna let you off the hook unless we have value reason and also there's somebody getting in the face to manage the situation.
Any other questions before we wrap up? And this way you guys can have a chance to the team on your role. Just want to say we have plenty of that. You guys want to maybe have some coffee and have some stuff. Anything else, guys? One more question over there.
are there agencies that can assume guardianship after all guardianship options are complete?
There are.
And that's a similar process to which you have to go through all that, or that's something else?
Hello, my name is Gregory Prosy of LifeWire News Service, and I'm here with Ron Serraccio of the Chief Clerk of Surrogate Court. How are we doing today, Ron?
Excellent, and thank you so much for having us come out here to share some of our information on what guardianship is for special needs individuals.
Well, Ron, it's our pleasure, and not only that, but we're very into interviews because we're part of the media department. Now, I have a mom and a dad that I live with that I'm very fortunate to have. What is guardianship?
Okay, guardianship in our court, and again, Gregory, is specifically to manage the affairs of individuals who, unfortunately, for whatever medical, intellectual, or developmental reasons, they can't manage their affairs in their life. And you know, the litmus test would be for them to understand the nature and consequence of their decision making.
You know something, Ron? I got to tell you. That is one reason why I count my blessings for the mom and the dad that I live with, who shower me and who feed me. I count that blessing. Now, Ron, you were telling me people can't manage their affairs on their own. And I know that parents are the ones that make the decisions. So what do parents have to know about guardianship?
Sure, and some of them are parents who make application, and also individuals like brothers and sisters or loved ones that are involved in the developmental disabled person's life, and they would make an application before the court, and the court always uses medical documentation to see. We want to make sure that the rights of the ward are adequately protected, so we want to make sure that they need a special guardian in their life to help them with their care and support and maintenance.
Very well, Ron, and I'm very glad to have met you today. Well, Ron, I got to tell you, like I said before, I have a mom and a dad that care about me and shower me, feed me, and my important thing is to count those blessings, because I hear about people who have problems, and I'm fortunate to be who I am. So thank you for trying to help us, and thank you for being a part of this event, Ron. Thank you.
Gregory, it's been a pleasure, and many thanks to Lifestyles for having us here again. Anytime, any place, we'll be back.
Ron,
God bless.
It's great to meet you. Thank you, Ron.
Be well.
Thank you.
Thank you so much.